Good evening, everyone. I'd like to call to order the Village of Biscayne Alliance Board meeting for Wednesday, April 16th. Time is 6 o'clock. Please call the roll.
Janie Anderson, Dale Bennington,
Present.
Rodolfo Bergantos, Judy Hammerberg, Michael Lanat,
Here.
Ashley Brene Green, Doreen C. Grant, Rafael Gutierrez, Vanessa Cherry present.
Good evening again, everyone. This is a meeting of the Village of Biscayne Park Code Compliance Board. The board is authorized pursuant to Chapter 14 of the Village's Land Development Code to ensure compliance with the village's Code of Ordinances. The members of the board are citizens and residents of the Village of Biscayne Park. We volunteer our time and are not paid for our services. The purpose of each hearing is to give any alleged violators the opportunity to contest the decision of the code compliance officer, which resulted in the issuance of a notice of violation, and to determine whether a violation of the village's code has occurred or is occurring. We are not authorized to dismiss violations based on hardships, ignorance, or the fact that others may be guilty of the same violation. These hearings are conducted in a quasi-judicial manner. Our responsibility is to act much like a judge in a court, and that is to hear cases presented by the village's code compliance officers and to hear contradictory arguments presented by the alleged violators. We are not authorized to change the code. The Village Commission is solely authorized to enact or revise codes. Conversely, neither the commission nor the village manager have the authority to overrule the findings of the board. Pursuant to Chapter 162 of Florida statutes, orders of the board can only be appealed to the Circuit Court of Miami-Dade County. We have the authority to assess and order the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code compliance officer's decision, we must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. All documentary evidence presented by the parties must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code compliance officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witnesses regardless of which party first called them to testify, and to rebut the evidence against them. If you intend to address the board you haven't signed in yet, please do so. Also, anyone wishing to address the board tonight, please stand, raise your right hand so that you may be sworn in. You're reminded that this board is quasi-judicial and giving false testimony can be penalized.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? You may be seated.
I do.
Do we have any additions, deletions, etc.?
No additions.
You need to sign in. Any additions or deletions?
No additions.
And we're ready? Ready to call the first case.
Doreen Grant, Code Compliance Department for the Village of Biscayne Park. First case we're calling on the agenda is in new business, 7.2, and it's for the address 771 Northeast 116th Street. It's case number CE-25-0092. Jenny Johnson, property owner, and counsel is on Zoom. They were found to be in violation. They were found to be in violation of section 16.14.1 double fee permits for a dumpster that was on the property without a permit. The property owner was out of the country and the contractor created this violation. However, the property owner came to the village in good faith, paid the fines, and this case is now in compliance. We're asking the board to close the case.
Fees have been paid.
Second, all in favor?
Aye.
Any opposed? Motion passes 5-0.
Thank you.
The next case on the agenda is in old business under section 6.1. It's for the address 826 Northeast 121st Street, case number EEN 22-383 for Jan Roots and wife Denise. This is a petition from two attorneys for a rehearing. This is regarding a violation FBC code and Miami-Dade County Code and safe structures. The description of these violations was village came to ask for an intent to lien for professional services for a case prepared for the Miami-Dade County and Safe Structures Board for invoice number for the record 00021200.05 dated March 5th, 2024 in the amount of $10,000. We have the village attorney present and counsel present for the mortgage company.
Brad, can I ask you to come forward, please? So we're rehearing because the property owner's attorney was not properly noticed last month. Legally, what is our responsibility in terms of noticing?
Our responsibility is noticing the property owner. We send them certified mail. We notice them by certified mail, which we did. We emailed the attorneys, each attorney. There are 3 attorneys on this case, and we emailed each attorney the continuance, because the initial notice was sent in January for the January hearing. Case was continued to February. We noticed the attorneys by email, and we noticed them in March again for a continuance. However, the original notice, everybody was noticed.
So legally, we don't necessarily have to rehear, but out of fairness, we should.
It's up to the board.
I would say out of fairness, we should. I mean, it's not a legal requirement, obviously, but the gentleman took the time to be here. And hopefully we can, rehearing it would be fair. How does everybody feel? Nope. Okay. One concern, very quick concern. Oh, I'm sorry, sir. Would you state your name and your relationship to the property?
Yes, my name is Caleb Hazing. I represent the mortgage servicer.
You know, Matthew Kramer,
He's not here, present at the moment.
and
Bill,
he's the one who basically
Requested.
filed
Correct.
for the rehearing.
Correct.
Been notified that a Bill Riley was supposed to be in attendance on his behalf as a step-in
you-
counsel.
I apologize. So you represent the mortgage company,
Correct.
but we don't have an attorney for the property owner.
We don't have anyone representing the property owner right now.
Brad, yeah.
Just Bradley Weissman, village attorney, and just so that
Oops, I think I just broke it. No, just so the record's clear, I am not here as in an advisory capacity to the board. I am here representing the village on this matter. So the board's aware of what my capacity is here today. I would suggest, and I understand the position that the board members have already allocated, but before you make a formal decision, I would suggest that you take note of several things. One, council that's present here today, who represents, I'm sorry, the mortgage holder, mortgage service, sorry. They were present at the last hearing and had an opportunity to be heard. Counsel for the property owner was not present. However, the property owner, I would submit, was properly noticed as it is indicated in your file and provided by Ms. Grant. As Ms. Grant has also provided the court, and she can give sworn testimony if needed, there were emails that were sent to both Mr. Kramer, Mr. Riley, and Ms. Sloat Rogers, indicating that the February hearing was being continued and being rescheduled to March. So there was formal notice. Well, I would say there was notice to the councils with regards to that hearing. And I would also just state for the record that neither Florida Statute 16212 nor any provision in the village's code specifically requires any type of notice whatsoever to council. The statute 162.12 deals specifically with notices and code enforcement matters, and it requires notice to be sent to the alleged violator. And it sets out how that notice, I know you're all aware, how that notice, so I won't read it to
Going
you.
into it, we knew there is no legal responsibility. And now that I'm hearing the gentleman present is not a representative of the property owner, I have to take back what I said. I just don't see the point. I have to tell you, there's no new evidence that they have presented. I still stand by my vote in March because there's no new evidence. We know it was a flat rate. Because it was a flat rate, there was no need for sectionalized documentation. And as was said last month, the village cannot be required to provide a document that does not exist. That's not how public records work. So how does everyone feel?
I mean, I just want to point out that the attorney for the property owner is the one that wanted the rehearing. We're spending all of our time talking about whether it be should or we shouldn't, and the attorney for the property owner is not here, right?
It was properly noticed.
So, I mean, listen to, there's no reason to go forward. If you make a motion or you make an ask, you got to be here on the other end. But, so I don't see any reason to go forward.
Rescind my comment. My motion would be that we do not rehear.
I'll second.
All in favor?
Aye.
Now,
So the original order stands?
Sorry?
The original order stands for intent to lien.
now, do I need a motion to make a suggestion on the order of enforcement? I'm a little uncomfortable with the word fine. It's not a fine, it's a fee. And I should have caught that before signing. How does everybody feel? Take a look at the order of enforcement so everybody can see what I'm referencing.
It's the fee.
I'm parsing words, I realize that, but it isn't a fine.
We have taken note. We will make a correction. We'll amend the order and have you sign it.
Is that all right with everyone?
Yes, that's perfectly fine.
Yes.
Okay.
Need to be a motion for that?
Oh, amending the
Just
order?
to be safe, just to be safe, I will. I'd like to make a motion to amend the order of enforcement from the March 12th meeting to replace the word fine with the word fee.
I'll second the motion.
All in favor?
Aye.
Aye.
Aye. Motion passes 5-0.
I would like to bring to the attention of the board that Mr. Bill O'Reilly, Mr. Riley is here. the attorney representing the owner, the case you just ruled on. Mhm.
Needs to be sworn in.
Please raise your right hand. Yeah, okay, sorry. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Okay.
And again, I apologize,
And
ran a
sir,
little bit late.
again, if you would identify yourself and your relationship to the property.
So my name is Bill Riley. I have offices located at 16343 Southwest 256th Street, in Homestead, Florida. And I'm the representative, the attorney for the property owner. And I was the attorney who appeared at the Unsafe Structures Board. And we came here, a colleague of mine, Matt Kramer, is the one who filed the request for the rehearing, because we didn't have the notice and nobody showed up at the March 12th hearing. And I believe, and correct me if I'm wrong, but one of the attorneys from the lender also requested for the rehearing. That's when I knew I was running late with the traffic and my surgery. But I thought maybe she would be here to do the presentation as well. Has nobody appeared from them? Oh, hi, how are you?
Hello.
I didn't know, I haven't met you in person yet.
Fortunately, I don't represent the property owner, and they wanted you here.
Oh, okay, okay,
So
great.
I couldn't-
Okay, great. The purpose of today's meeting is that we had two hearings before the Unsafe Structures Board. The Unsafe Structures Board ultimately ruled in favor of allowing additional time for the property owner. And I was the lead attorney at that hearing. I appeared on both occasions. I did 90% of the presentation before the board. The person who we're here about today with his invoice of $10,000 spoke at one of the hearings. I don't believe he spoke at the second one. Spoke at the first one. Yes, ma'am.
I'm going to stop you just
Yes,
a
ma'am.
moment. There seems to be a continuing misconception, even though it has been explained right from the beginning. The charge from the building official's company is not based on the time he spent at a meeting. It is based on the case preparation for a case that goes back decades. So
And I-
that was said in December, and Code Manager Grant explained it then, and it's said again in Mr.
Sure.
Kramer's letter. It's not accurate, sir.
Sure, and I don't bill for my time just at the hearing either. I do preparation as well. And that's part of our presentation is that nobody really just bills for that time for the hearing. They also do the preparation. So we've asked for background documentation with regard to this lien or this $10,000. We've gotten some documents. None of them were provided before March 12th. The ones that have been provided since then have not been detailed. They're not itemized invoices, not that I've received at
And
least.
they won't be, sir. It was a flat rate. There will not,
Okay.
there does not exist.
Okay. Well, if that's the case, if it's a flat rate, then that violates Florida statute 6, and I'll recite it for you. We
Yes,
did,
you
we-
would.
go ahead. Oh, I'm sorry. I thought somebody wanted to interrupt. So, oh yes, I just wanted to pull it out here. So it's chapter 612. I'm sorry, chapter 162. And part of that chapter discusses about code enforcement leaves and cost recoveries. And it has to be efficient, it has to be equitable. And if there's a flat fee, the property owner should have notice of the flat fee, should agree to it beforehand, as part of the appeal to the Unsafe Structures Board. We have to pay the county a fee, and at times there's cost recoveries there too. I've been practicing as a zoning attorney in this town for 24 years. I've never received a flat fee invoice for an unsafe structure board hearing, even remotely of $10,000. I don't charge my clients $10,000 to do an unsafe structure board hearing. It is arbitrary. We think it's capricious, and we think it is certainly not efficient, not equitable. Which is reason we came to this board, because when you think of what a property owner should do, should be assessed for and should be liable for, it needs to be something that is equitable. In this case, if you talked about somebody who was making $500 an hour, which I'm sure this individual does not make, and if he doesn't make the $500 an hour, that would be, if he made $500 an hour, that's 20 hours associated with just reviewing that in preparation and attending that case. That is exceedingly too much time. I don't spend that much
So
time.
you do realize this case is not a recent case.
I realize it's not a
Literally,
recent
sir,
case.
it is decades.
Yes, and that's
Everyone
why,
sitting in this board can confirm it is
In
decades.
1996, it's been a vacant, abandoned property since then, and
but that's aside the point. The question is, when did this individual get hired? And I would like to question him, but I don't see him in the audience today. And if he's not here, then I have a due process argument, because I have the right to question him about his invoice. When did he get hired? What is his normal rates? I'm sorry, did you have something? Okay, so what the attorney was telling me now from the lender was that, and he's right, this is a request for a rehearing. So I'm getting ahead of myself when I say that I have a due process argument. What we're saying is that we have grounds to question this invoice. We think it is, and we think that the grounds are pretty obvious, to be honest with you, and to be candid with you. If the rehearing is requested, then that individual should show up and we should have the right to question him. So I'm getting a little bit ahead of myself in all fairness.
With me, that's very interesting.
Yes, ma'am.
sir, that you just said that because Mr. Kramer, in his email, says, undersigned counsel is not requesting.
That's what he just told me, because I'm getting ahead of myself, because we're here for a rehearing, requesting a rehearing. This is not the rehearing itself.
This is the rehearing.
It's the motion.
So yeah, that's why it's a little bit confusing. That's why I got just as confused as you did a moment ago. So, so I had the same, transgression. So I apologize about that. But they're right. It is a request for a rehearing. And that rehearing would be at a different date when we have the right to question that individual. But again, I know that it goes back a long time, but this individual wasn't hired at that time. He wasn't reviewing information that goes back, a decade. He wasn't hired 10 years ago. If he was hired 10 years ago, and if he testifies he was hired 10 years ago, I won't have the objection. But that's not the case. That's not the facts that I understand to be truthful. So, so that's why we're here. Just a recap, we're asking for a rehearing. We would like to have the opportunity to say what is fair, what is equitable, what should be actually charged to a homeowner. And
Sir,
that's the whole purpose.
Let me
sir.
interrupt, because this is, again, it's a motion for rehearing, right?
Yes, sir. Yes, sir.
So you're asking for an opportunity to argue the things you're trying to get into now at another time.
Well, I'm giving you like a background. Yes, but yes, sir.
But what is your, what do you say to the fact that, we've already ruled on this? What is the basis for the rehearing? Like,
So-
what is it grounded in?
So let me elaborate on that. I mentioned at the beginning, but on March 12th, when you had your hearing, there was no notice.
No notice to who?
No notice to the property owner, no notice to their counsel, which is
Okay.
me, Mr. Kramer.
Well,
It is-
you were
it is-
late. You were late. So
Yeah, sure, I'm
I
sorry.
think that,
You have
I
something
think,
to add?
well, I think that Ms. Grant had gone through in detail about the things that were done. So there
Okay.
was notice.
I object to that there was notice. I don't believe that there was notice. They knew I was counsel of record. I've been counsel of record not only at the Unsafe Structures Board, but at meetings with them, on emails with them. I never received notice.
But is there a statutory requirement that you, as a counsel of record, receive notice?
Yes, I believe that
Under
there
what
is.
statute?
I believe there is. So
What
I believe it all falls within under 162, the code enforcement statute. And when you have an attorney that appears of record, this is a quasi judicial proceeding. It's not judicial, of course, but it's quasi judicial. And those elements of equity do come into it. And I believe that I'm entitled to notice.
Okay, and
As the
you're
property
basing
owner's
that, and
representative.
you're basing that on Florida statute 162?
Partially and partially case law and partially the rules under that we fall under quasi judicial
Is there a
proceedings.
particular case that kind of leads on this that allows for the, the proposition that Florida statute is 162 is interpreted as such that, that a attorney of a property owner is the right to get a notice of a hearing in a quasi
They're
judicial
they're not only,
structure?
they're
like
they're
this?
required to. Yes, ma'am.
Receipt from your office that says it. There's a thank you on that from your office back to us.
Okay, but the question still stands because I'm curious to know if there's case law to rely upon outside of Florida statute 162. And I think, Mr. Weissman, are you here for this hearing on behalf of this Biscayne Park? Okay, okay, so no, yeah, because I know I'd like to hear from you, but I just
Okay.
want to, no, I would like to hear from you after.
Okay.
Yeah, you still have a pending
I'm
question.
sorry.
That's an opportunity to be heard. So I was-
And I want you to be heard.
Mr. Riley, is that not from your office saying thank you? To
Yes,
the motion at the bottom that says that it will be heard in March?
so it says that we're requesting a continuance.
No, look at the bottom of the letter. It has the date in March at the very bottom of the letter.
Oh, it's an email and it
Was
does
it-
say continuance to March 12th.
Right.
Yes.
And you're saying you weren't noticed on it.
No.
Notice, sir.
So
But
there
you-
was notice. You
No.
have the notice in your hand and the receipt from your office that says, thank you.
Yes. So this is not notice. This is an email. Okay. When you get notice, it's a statutory required notice.
Okay, well, let's get back to that.
Was the property posted?
Sir.
I mean, I would like to know. I'm
No,
curious.
Well,
Yes, sir. Go ahead. I'm sorry.
yeah, we have the opportunity to ask the questions today. And the question that I have pending for you is that under Florida statute 162, which you relied upon to say that the attorney of a property owner is required to get notice of a quasi-judicial hearing such as this. And then you also mentioned that there was case law that was also reliant upon your argument. So I'm asking you, is there a particular case that stands for that proposition? Or are you just relying upon the statute?
There's case law and there's statutory language that goes into this, and it should be as a matter of judicial notice that when an attorney appears in any matter, the attorney's entitled to have notice. Okay, that's our fundamental judicial system of due process and fairness. Okay, when you appear and you represent, you appear as an attorney for a client, every judicial proceeding that exists in our United States has that same procedure. Whether it's
I happen to know-
judicial.
I
whether
happen to
it's
know a little bit
zoning
about that. I
hearing.
know that you said that you've been practicing for 24 years. I've been practicing for about 35 years. So I'm aware of
And you don't
that.
think you're entitled to notice on
I-
behalf of a
I'm-
client?
My question to you is under the statute that you just relied upon that says you're required to get notice as an attorney for a property owner. You also said that you relied upon case law. I asked you what case it was. This is your motion for rehearing. So you should be here ready to argue all the reasons why you should get a rehearing.
I am ready to argue.
So do you have a case name for
I'm
me?
ready to argue because I don't have a case specifically. It says an
Okay.
attorney is required to have notice. I think
Okay.
it goes for judicial notice.
But you did rely upon the statute. And I do want to hear from Mr. Weissman because he is the village attorney and I'd like to ask him that question.
Sure.
But I also want you to know that this board, and I've only been on this board, what, 2 or 3 years? We have seen more attorneys on this property than I can count. So I would say you're at least the 6th or 7th we've met with this case in the last few years.
Really? I'm the only one I know of, me and
No,
Matt
no,
Kramer.
no, no, no.
Honestly, you know.
I don't know of any other ones.
Who's the attorney
Would-
changed regularly, but anyway, not the point. Brad, come forward, Michael.
Sure.
So, Mr. Weissman, did, the question that I just asked, counsel, under Florida statute, is your interpretation of it that the attorney for a property owner requires notice of a quasi-judicial hearing such as this?
Under chapter, and again, just for the record, Bradley Weissman, village attorney, under chapter 162, specifically 162.12, which deals with notices in code enforcement matters. The only requirement is that the violator, or in this case, the property owner, is to receive notice. And it prescribes the manner in which notice should be had, which is either by certified mail, posting under certain circumstances, but it lays out. There is nothing in chapter 162 that would prescribe or require that notice be given to counsel for the property owner.
Okay, so you don't see anything in your analysis of the statute. Is there any case law that you're aware of that expands upon the notice requirement to the attorney for a property owner, or as the statute says, a violator?
Not that I'm aware of it as I stand here today. I would also indicate, what we're here for today is an issue that's basically a due process claim on a motion for rehearing, with counsel asserting that he hasn't had an opportunity to cross-examine the chief building official with regards to the agreement that he had with the village as it relates to the inspections, not just the presentation of this matter to the Unsafe Structure Board, but to the inspections that were done, whatever research was done, meetings that were had as a result of leading up to ultimately the presentation that was made to the Unsafe Structure Board by the chief building official representing the village in this matter. I would suggest to this board, most respectfully, that council did have that opportunity to cross-examine the chief building official had he been here. And I'm not speculating, and nor do I care to speculate why, whether it was strategy or whatever reason that council did not appear. But I believe I would submit to the board that, as we stated, there is no specific requirement for council to receive notice under Chapter 162. I'm not aware of any case law that would require it. Plus, the record reflects that Mr. Riley, I'm sorry, make sure I'm not misstating your name. No, I'm sorry, give me 1 minute. Mr. Riley, that the Riley firm was in fact noticed, that they were noticed on February 6th of 2025 at 12:24 p.m. An email was sent to the office indicating that the February hearing was going to be continued at the request of the village and was going to be rescheduled to the date of the hearing in March, which was March 12th. And that was, as you've all pointed out, was acknowledged by Mr. Riley's firm.
So the bottom line is that the hearing was March 12th. That's the one where all of this cross-examination could have taken place, and that's the one where they did not show up.
That's the village's position. And that the chief building official did provide testimony before this board. I believe Mr. Kramer, you're not Mr. Kramer. You're-
No, Mr. Hazen.
I'm sorry, Mr. Hazon?
Hazing.
Hazen was here on behalf of the mortgage holder or the servicer, and also had the opportunity, if he so choose, to cross-examine.
And just so I can kind of put it all into perspective here, the statute that we were just talking about that doesn't require the notice to the attorney, you're saying that irrespective of the fact that there is no statutory requirement and none was needed, part of your argument is that irrespective of that, notice was provided and acknowledged by the Riley firm.
Correct, and there's no specific notice that's required. So the fact that notice was given is sufficient.
Exactly. Okay.
Receipt was acknowledged, which that to me would be critical. We can say we send an email, but we all know what can happen. The receipt
It also
was
says
acknowledged.
continuance. I just want to make sure our position is clear. We did not receive an itemized invoice. The itemized invoice, they say it doesn't exist. They say that it's a flat fee. We never agreed to the flat fee. We never received the proper notice under the Florida statutes. We still contend, I don't, I'm setting aside the email at the moment. The property owner under 162 did not receive the exact notice as required under the statute. If you'd like me to belabor that point, I can. If we don't get an opportunity to be heard, I will follow a request in court. We will go under court to say we have not received due process because it's just not equitable that a property owner gets a $10,000 flat fee that can't be justified. Why is it not $100,000? Why is it not $25,000? We never agreed to anything remotely like that.
I'm ready to make a motion.
So if we want to, and I understand your position and I understand that your motion is going to be, and I respect that, but I want to let you know that I will be filing a request in court to appeal this matter because this is not the way that you treat somebody. So with that said, if you would like me to expand upon the notice that the clerk was talking about, I'm happy to do that. If not, I just want to give you the transparency of where I need to proceed. I think there's no harm in having another hearing that can avoid all those other steps so we could have our due process. And if we had our due process, then I wouldn't have to take those extraordinary
But again,
steps.
sir, due process could have occurred last month. You were noticed. The building official was here, Mr. Weissman was here. I'm sorry.
No. Says continuance. You can see my condition today, okay? I had to have reconstructive shoulder surgery, okay? Regardless of myself and my existing condition, okay? I'm asking for a one-time rehearing so I can question the witnesses. We didn't, and again, the property owner's notices, I'm contending are not correct, okay? If you want to avoid those extraordinary steps, we could have a 1-hour hearing that avoids that. If not, I want to be transparent, and I don't mean to be aggressive or anything like that. I just want to be transparent, tell you what our next steps are. Because that's just, the $10,000 fee of a flat fee is just not, without some type of evidence, without some type of backup material, is just not appropriate. And we didn't have any of those informations before the March 12th hearing, and that's not disputed. I respectfully request that we just have one hearing for 1 hour, and I'll ask no more than 1 hour to have that hearing. And you can rule at that time.
Before I make my motion, Ms. Grant, what notice was provided to the property owner or the violator or whatever you want to call it, as the statute points out, with regard to the March 12th hearing?
Yes, it was.
How?
Sent it by certified mail.
Okay, and I think that Mr. Weissman said that's one of the methods under statute 162.
To what address? Can I ask to what address? Because the address is the question, that's the deficiency, sir.
What was the address?
The certified mail.
So
Certified mail.
by statute, we are supposed to use the address that's in the tax assessor's, on the tax assessor's roll. That's what we use. That's where we send our certified mail. It's to another attorney.
Okay.
We always send our certified mail to them, but we make sure we email the attorneys just in case this mail doesn't get to the property owner. We email the representing attorneys.
I'd like to make a motion in, I think it's case number EEN 220383. Is that it? Yeah, 220383. Based upon the evidence that was adduced today with regard to the motion for rehearing and the Florida statute 162, the lack of any case law that says it expands beyond that, I'd like to make a motion to deny the motion for rehearing.
I'll second it.
To deny.
Deny the rehearing. I'll second it.
Motion to deny the rehearing. All in favor?
Aye.
Aye. Any opposed? Motion passes 5-0.
4-0.
4-0. I'm so sorry. Old habits die hard. Thank you.
The next case. The next case we are going to call is section 6, and it's under 6.2. It's for the address 860 Northeast 120th Street, case number CEN-24-701 for Catherine Brownell. The next case is for her as well. I'll call them together. For the record, it's CEN-24-702. Catherine is on Zoom with us today. If the board recalls, these cases have appeared before the board, I think, 2 or 3 times. We were unable to locate Catherine. Fortunately, we have. Catherine was very ill, and that's why she was not able to respond to the notices. She's requesting an extension in order for her to go through the process of applying for permits so she can comply with her violations.
An idea of what a realistic time frame would be.
Catherine is on Zoom and she can speak for herself.
You sworn in?
She was sworn in. Hi, Catherine.
Hi,
Can you hear us?
yes, I can.
Ma'am, my question was, you're looking for an extension. Can you help us to figure, what are you looking for? What is a realistic date for you?
Well, got a real estate agent and I'm going to sell the duplex. So I'm not quite sure how long permitting and that kind of stuff needs. But he said that he would oversee and take care of getting a driveway in there and any violations that may have been incurred.
Who is he?
He came down there, he spoke to you, I think. Jeff, I'm sorry. I have to go look up his last name. You have to forgive me. My memory is not good now.
I think he's on the line. Is there a Jeff on the line?
Jeff is the realtor, but he's not here.
I don't think so.
That's for another case.
Oh, okay.
That's for another case.
Yeah, I didn't,
Wait.
because I don't think he was aware of this meeting.
So is the house listed or is it being sold to Jeff?
No, he's the realtor, and he just in the past 2 weeks has gone in and looked at the duplex and said, this is what needs to be done. And so that's what we're going to be doing
Okay.
so that I can get it on the market.
You're
'Cause I-
prepared to put the driveway in and then put it on the market for sale?
Yes, if that's what I have to do, yes. I mean, I can understand the need for the driveway.
So, well, you'd be able to have a permit pulled by May the 20th?
We're in April, May. Yes, I do believe so.
That would give you a little over a month to get the plans, your survey, and then the permitting process to have a driveway permit pulled. It would have to go before planning and design,
Okay,
and they will meet on May the 5th and May the 19th. And
May 5th and 19th.
yes,
Yes, ma'am.
you would need to, they would need, the design would need to, the application and design would need to be submitted a week before that.
Okay,
They could review it and then they would hear it on, decide on May the 5th or May the 19th. Would that give you time?
I guess it'll be enough time, I guess, unless there's some type of problem with whatever design is
Go
submitted.
to June. Let's go to June.
Well, ma'am, in all fairness, why don't we give you sufficient time until June the 15th?
To June 15th?
think that's
June
realistic.
15th. That's, to have a permit pulled and, begin the,
Okay, I will get in touch with him tomorrow and let him know what transpired. And I will have him, and I do have an attorney, but she's worse off than I am. But I'm sure we can get this done.
But your realtor can co-speak to the code and building people here.
Yes.
We've met with him before.
Want to make the motion?
um, yes, so if that sounds good to you, ma'am, I'd like to go ahead and make a motion that in case number, I'm gonna do it for both of the cases, the duplex.
Correct.
Yep.
And, that on case number CN 24-701 and case number CN 23 4, no,
702.
702, that a violation has occurred and give the property owner until, June the 15th, pull a permit. If not, commencing June the 16th, a $250 fine thereafter. Fine,
Okay.
Second.
I do.
Violation fine is $250 and there's an administrative fine of $250 for total.
Okay.
So it's a violation fine of $250 and a administrative fine of $250.
For each case?
Oh, for the one
For both?
property as a whole, for both
Okay.
cases combined.
Okay.
Because I think the design could go as a whole. but
I
the
understand.
property owner is the one person.
Yes.
And for the permit to be pulled for both properties
By June 15th?
by June 15th.
Okay.
or
I second that.
Okay. We have a motion and a second. All in favor?
Aye.
Aye. Any opposed? Motion passes 4-0.
Thank you, Catherine.
I want to thank everybody for their help today.
Thank you, ma'am, for coming into the meeting.
Thank you. Good evening.
Next item is 6.4
Yep.
for the address.
Bear with
Okay.
me just a second. I'm sorry. I want Dale to, if you would, Dale, repeat the fines so I get them written
Yes.
accurately.
The fine is, the violation fine is $250.
Okay.
Plus an administrative
Got it.
fine.
And then the daily.
And 250.
Gotcha.
daily.
I just wanted to make sure because I keep my notes.
That's
Thanks.
for the combined case.
Yes.
The next item, 6.4 for the address, 1105 Northeast 117th Street, case number CEN 23-449, property information protected. We are asking for a revised order of enforcement. Property owner is here. They were found to be in violation of chapter 5.6 off-street parking for their driveway, which does not meet the design standards set forth in section 5.6.7. Mr. Stefano is here.
Good
Information,
afternoon.
as a representative of the property. He's the property owner.
Oh, has there been, I see that there was a back and forth between, I'm guessing that's the contractor in February. Doreen, I guess he got with Denisha.
Yes,
I should have had it.
yes, there was some communication with the contractor. Stefano was not well for a long time.
October, and that, when Denisha put out that it had been rejected,
Right,
the next contact wasn't until February.
wasn't until February.
And
Fortunately, we reached out to Stefano and then he came to the office and let us know what happened. He has fell out with his contractor and he's started from scratch. He got all the paperwork
Southport.
from the office and permit is in. They are now going through the process of resubmitting the permits. We met with him twice in the office.
He is in the pipeline.
Oh, yes. He came to the office. We met with him twice. We had a long meeting in the conference room. He explained to us what happened and He's now redoing the paperwork.
I did everything, ma'am. I paid all the fees, surveyors. I hired a contractor. The guy just, I don't know, I've been having big problems with him. Huge problems. I may end up having to get somebody else because I'm ready to go. I even took out a loan. And I'm gonna have to
South
resubmit it.
Florida can be a challenge.
Yes, to say
Anyone
the
who's
least.
done work on their home. we
I'm-
can
I'm-
do it. It's a
I
challenge.
promise you I'm on it. I can prove it. I've got everything here, everything. I made everybody aware of it. We went over it.
But, and I get that.
So what's going on? Basically, your contractor is holding you up?
He's just not showing up. I mean, if you'd like to read my cell phone, the letters I've sent this guy,
We read it. It's okay.
The original,
let them read.
the original.
You know, is he contacting you or is he just,
No, he's just, I don't know what his problem is.
how long has it been?
It's been months. So I don't know what to do. I'm gonna have to fire the guy and get
mean,
somebody else.
Does he
And
owe- So you got money that he owes you work for?
I don't even care. I just want to get this done with. I'm ready to hire somebody, and I even inquired as to how I find somebody decent. And they said that they couldn't give me any names. Biscayne Park said, we can't give you names. So every time I see a driveway now, I'm stopping, I'm getting business cards. I'm doing everything I can. I don't know what to do. I'm disabled. It's killing me, but I'm doing it.
I had the same problem. And I ended up hiring a former member of the board that who did driveways and he recused himself and he did it, but I had the same exact problem.
And I don't know what to say. I feel sorry about it. I want to comply. I've done everything. I got all the paperwork, everything signed, everything's, he even lied to Miss Grant. And I showed it to him. The guy lied to her. He did. Am I wrong, Miss Grant?
That's correct.
He lied to her.
I see no problem. I'm sorry.
I just have a question, because I see there's a daily fine, right?
Mhm. Has the daily fine kicked in?
Yeah, the daily fine kicked in back in
Well,
October
we
the
don't,
first.
we don't know.
So what had happened is, what had happened in the other cases, he pulled the permit, submitted the permit, so the daily fine didn't kick in.
It said.
I mean, I'm going to
oh,
respectfully disagree. It doesn't say, the order of enforcement doesn't
Doesn't
say apply for a permit. It says pull the permit. He has not pulled a permit.
Well,
Those daily fines should have started in October.
ma'am,
So
Hang on.
Go ahead.
Mr. Bridich, I'm so sorry.
that's all right. Go ahead. Go ahead. Go ahead.
Just a second. Now, I
he
understand.
she's right. He submitted the permit, like he says, the contractor submitted the permit but did not go through with it.
Right.
So what happened in the past was, correct, what happened in the past was once the application process started, we gave them a little bit of leeway. And that's what happened here. They applied before the fines would start running. However, we are asking for a revised order of enforcement.
I don't
for
believe
that
that's
reason.
ever been this board's intent. When we say pull
Pull the
a permit,
permit.
we mean
Issue.
gotten paid for and
Absolutely,
issued. We don't mean just fill out the paperwork.
right.
What were you asking for? You were asking for something, a revised,
Revised order.
that says,
That changes the date of compliance, and the fines would be up to the board if you want to do the administrative and violation fine. which I
Well,
think
that's on,
wasn't in
that's on
that.
us at this point. It should have been done. I don't think it's fair to retro it. Gentleman doesn't know it's being retroed.
Right.
Much as I don't like what happened, I don't think two wrongs make a right. So what I would like to do is change the date.
Revising.
I'm being
Give a
realistic.
different deadline.
thinking June 15th. And if he doesn't have an actual issued permit by June 15th, then the 250 daily fines kick in.
and that's to pull the permit.
Issued. And paid for, yes. Not just apply, but have the permit.
In your hand.
May I say something?
Yes, sir, sorry.
That's all right, ma'am. He had submitted to the board, I can't. think of
Design,
it.
yeah.
He had submitted the drawings, the plannings, and they rejected it.
Right.
He rejected it and he never corrected it and brought it back in.
That's why we've upped the date. I know this has been kind of perfect storm of issues. So that's why well, I'm sorry, depending on how my board feels, I'm suggesting moving the compliance date to June 15th, but that means you have a permit in hand. If not, then a $250 daily fine will commence on June 16th.
I understand, ma'am.
According to my co-board members.
I think you might need to get into the contractor.
That's what I think I'm gonna do, sir. I'm
Then,
not, I'm
yeah.
not gonna, I
This
can't take
guy's
a
not,
chance. He's not responding.
It's time to let him go.
I'm
Okay.
sorry.
I'm sorry. In case number CEN 23-449, a violation has occurred. Give the property owner until June 15th to, I'm sorry.
I hate to interrupt.
No, no.
Shouldn't the motion be to revise?
Revised order.
Thank
Enforcement from-
thank you, yes.
Yeah,
No.
we're not changing.
I
things. It's
appreciate
same
the
thing,
in-
you're just
From
revising the date.
August 7th. My motion will be to revise the order of enforcement from August 7, 2024, to change the compliance date to June 15th of this year, 2025. If not, if a permit is not pulled and paid for and issued by then on June 16th, the $250 daily fine kicks in.
Understood.
Second that.
All in favor?
Aye.
Any opposed? Motion passes 4-0.
Good luck.
Thank you, everybody.
Sir.
That with contractors currently putting them in, you may want to stop at a home that recently had one put
Mhm.
in and ask them. Say, you want to see you have it, what did y'all use, how did it go? Thank you.
Next item, 6.5, for the address 11450 Northeast 10th Avenue, case number CEN-22-105, Alejandro Bowers and Audra McCollum. We came here for an intent to lien. They were found to be in violation of Chapter 5.6 off-street parking for a driveway that doesn't meet design standards. Property owner is here. There has been some issues there. We have met with the property owner in the office. We have been to her property and met with her there. We have been in communication by email and telephone. She has been trying to do what she's supposed to do. However, she has a life-threatening illness. She has been in and out of hospital. We have seen the evidence of that.
Read the email, yeah. Obviously going
She has been through a lot, and we are asking the board to give her some time.
Honestly, I'm sorry, I need you, even though I know who you
Oh.
are, to introduce yourself and your relationship to the property.
Sure. I'm one of the owners of the property, Audra McCullum. My ex-husband's name is still on the property. He was supposed to have paid off the property in 2019. He has not done that. I'm sorry. I've taken some sedatives so that I wouldn't start crying because the whole. I'm sorry.
Don't worry, please don't apologize.
So,
We can,
so yes, I am here. He is not gonna be taking responsibility for any of this. That's fine. I have been speaking with Doreen. I tried last year, I believe, or maybe it was at the very beginning of this year, but I think it was last year. I contacted a contractor who did the driveway of the house located directly behind mine. It used to be owned by Audrey. It faces the park, and I really liked how they did her driveway. So my neighbor behind me, Carlo, gave me his contractor's information. They came out to my house. I got an estimate from them. But the thing is, and I'm not sure if you're familiar with Audrey's design of her driveway, it kind of has like, it starts like a semicircle and then it's like a pad and it just stops. And I was like, oh, that's kind of neat. And then I was like, yeah, I like that. Let me get the same thing. And then I thought about it and I was like, it's kind of weird. No, I'd strike that from the record.
the whole
It's
design thing can be tricky.
yeah. So I just thought, you know what? My two sons are getting older. one's about to turn 15, they're gonna want to be driving. I might as well do a full semicircle so that when we
You've got the
exit,
space. So you
we
will
have
get
this-
Grief later on, yeah.
so, yeah, I thought, like, if I'm gonna do it, let me do it right. So I had them come out again. They quoted me for 7,200 for, they're gonna widen a little bit if the plans are approved. They are working on the drawings. From, I believe he measured and it's 8 feet right now, the width of my driveway, which just goes to my garage. They're gonna widen to 10 and then do a 10 semicircle.
Audra, realistically, give us a date. What do you think?
I
the whole-
believe it'll be just dependent on how quickly the meetings go and the permitting process. He told me that once the paperwork is approved, that it won't take him, he said 2 days. Now, I know
Our
how,
only concern is, our requirement is that you pull and have obtained a permit.
right,
Technically, via the permit, you've got 6 months?
oh,
months,
it'll
yeah.
be done
But
once I get it.
Realistically, when do you feel you can have your contractor in place and have
He's
applied for the permit?
He's working on the draw. I have the money to pay for it. The thing will just be dependent
Would
on,
June 15 work for you?
I'm sorry, couldn't hear
Would
you.
June 15th work for you?
As being finished
Have-
or
hold the
have the
permit.
permit?
Your permit in hand?
I believe so. If the does that mean the design has to get approved first though, right?
Yes,
Okay.
there would be, 1, 2, 3, planning and design, meetings prior to that. Each meeting, you have to have your design and, application submitted a week before, correct?
Correct.
A week before. So June the 9th is the, furthest away. That means you would have to have it, submitted by June the 2nd, which gives you a little over a month to have, for your contractor to have all the stuff.
I asked him to have it submitted today and he was gonna try to have it ready.
So much the
So
better.
wait a minute, so that would be so much the better. We're trying to work with you.
Just want to give you,
Yeah, no, I really truly appreciate it because I'm sorry I missed all the previous meetings, but I was shut down.
Because if your contractor, something else is needed, then you have 2 more hearings that he can get
Okay.
the design, get whatever was missing and resubmit it. So that would be 3 hearings.
if you can make an earlier hearing in case stuff happens, you can correct it and still make the compliance date.
May we make a request to the board?
Yes.
The property owner has a fine that has been running, and I believe as of today is at $98,000.
Right.
We would like to ask the board to stop the fines. Once she complies, she can come back and ask for a reduction.
That
We-
was part of what I was going to ask about. Well, actually, not really to even stop them, but to note that she might ask, after it's completed, ask for a fine reduction and give the circumstances. But
She, in other words, Audra, we'll stop the daily fine accrual. We can't make it go away. We can't even talk about a reduction until your project is complete
Completed.
and final.
Right, I
Just the
understand
permit,
that.
but complete
No, I
fine.
understand that.
Then you can come back, present your case and go from there.
Okay, I mean, I'm counting on him. Today is Wednesday. I mean, if I had my way, you guys would already have these drawings. Hopefully if they're in by Friday, but you're saying the first, he would have to have them in by June 2nd?
No, no,
That was
no.
the latest.
At the latest.
No,
At
that's
the
for
lake.
the last hearing. There's one
Oh,
on May
so
5th, so
there's-
you would have the, sometime at the end of April, you'd have to, have the plans.
To make that May
May
5th
May 5th,
meeting.
which is even
Week-
better.
Week earlier.
And then one for May 19th. You'd have to have it by before May
12th.
12th.
Do I need to appear at those?
No, your contractor should be.
Okay,
But I will
Yes,
tell
yes.
you, it's always better to have the homeowner there in case the question comes up. I have
Okay.
always gone
is
when
it
I've had,
possible to appear by Zoom?
I'm not sure, but
Because
it's,
I'm,
Ask,
Yeah.
ask the building clerk.
Okay.
You go and you fill things out?
I will do my best to be there if it's possible by Zoom. If for some reason I'm
Because let's
at
face
my
it, I don't care
mom's.
how good a contractor you have, it's still your world.
Right.
Right. No,
And
it's,
if there's a question, then it gets booted till the next meeting rather than you could answer it now.
I see.
No other
I will
questions?
do my very best to make all the,
Make a motion.
what,
No other
can I
questions?
ask
I'd like-
why there are three, meetings?
You only have to go to one. If it's approved, you only have to go to one. We give
Oh.
you enough time so that if it's not ready for this next meeting,
Then
it
you
can be
can
ready
fix
for
it
the
at the
next
one.
meeting. Or if there's a
Okay.
problem at one meeting and they want something revised, you've got a couple of meetings.
I mean, is
Sometimes
there
stuff-
something I would think that, so it would be a
I'm
1,200?
gonna help you out. I'm gonna go ahead and make a motion. This will help you out, and then all of your questions should be to the.
Lorraine
Billy?
can answer.
Yes, to us.
You know how to run a meeting.
Yep, yeah. No,
Keep it short.
This is only for your code here, for the issue before us.
I appreciate it.
Getting the permit, talk to them
Okay.
over there. So in case number CEN 22 105, I'd like to make a motion to stop the daily fines that are accruing from the order of enforcement and to give the property owner until June the 15th to have a permit pulled and issued. If not, the fines will revert back to the day and continue.
Thank you. I appreciate your consideration.
All in favor?
Aye.
Any opposed? Motion passes 4-0.
Thank you very much.
Thank you, Audra. Good luck.
Any questions on the motion?
We got it.
Audrey, you don't have to stay for the rest of the meeting.
The next item is 7.4 for the address at 981 Northeast 113th Street. It's case number CE-25-0064, Renee Alvarez. He was found to be in violation of Chapter 16.14 double fee permits. He installed an air conditioner without first obtaining permits. Mr. Alvarez has since applied for permits last night.
Yes. And it's not installed during the flood. The water damaged the mini split, and all I was doing was replacing the mini split. So I wasn't installing something new. I was just replacing what was there.
But according to code.
Yeah, I know.
it's-
I know now. Yeah.
Electric.
Yeah.
Any questions from the board?
Um,
Sir?
I have no questions. You know, I was made aware. I went ahead and I had to find a person.
No, you should have gotten that permit first. Okay.
Right. I know now. Yes.
So you haven't paid for the permits yet? You applied?
Yes.
So you need to make that payment for us to consider this case.
Okay.
So as of today, we don't consider this compliance.
Okay. So tomorrow I'll come by and I'll pay for it.
Paid for it.
Yeah.
Right.
You have to pay double permit fees because you didn't get the permit before you did the work.
Right.
Okay. If there's no questions, can I have a motion?
It seems I'm here.
Sure,
the
on
whole
case
time.
number CE-25-0064, violation has occurred, assess a fine of $250 and have the permit pulled by. We normally get that.
Mon-
I don't think that, they don't go in front of P and Z, do they?
No.
No, right. So you don't have to worry about P and Z.
For the order of enforcement to go a week.
May 14th would be fine.
Today's the 16th. I mean.
April.
from
May.
now-
April.
I know, April.
Mhm.
30th, April 30th.
And have a permit issued by April the 30th, if not, a daily fine of $250. given the double permit fee, I'd like to waive the administrative
Yes,
costs.
agree. I'll second.
Thank you.
All in favor?
Aye.
Any opposed? Motion passes 4-0.
All right, guys, I'll miss you until the next time. Let's go ahead.
All right.
Next item, 7.6, for the address 10910 Northeast Ninth Court, case number CEC 24-0114 for Prime Realty Network LLC, in care of their registered agent Garcia Alfonso Rafael. They were found to be in violation of Chapter 5.6.7 of street parking. A driveway parking surface does not meet an approved driveway approach. We are asking for an order of enforcement. Now, they have applied for a permit, and their permit has been approved by P&D, and that permit is now under plan review. So this would be a finding of fact.
Have they paid for the permit yet?
They have paid for the permit, it's under review. It was approved by P&D.
If I may add, they haven't paid because the permit is under review. So once, once,
Yes.
once,
It hasn't been really fully approved.
Approved, then they pay at the,
Yes,
thank you.
thank you.
So, yeah, so what's the issue here? The parking,
Design review?
Correct, this is,
Go ahead.
yeah, this case was issued last year.
Who does it go to after P and Z?
It's in building review right now.
Right.
Thank you.
P and Z
Approved it.
Right.
It's gonna go through the different phases of the building review. Once approved, he'll pay for it and they'll have a permit.
so what's the violation? Why is he here?
We issued a violation because their driveway doesn't meet standards
Yes.
We issued that one.
last year,
Oh, I see.
November.
December third.
December the
Yeah.
30th.
March 31st.
First.
Yeah, in December, we had just recently bought the property about 5 days before that. And then we got the violation, and we had some financial issues because we had just bought the property. So I did go ahead and ask for an extension on the driveway. And then when the extension ended, we applied for the permit, and I came here last time, April 7th, and got it approved.
Was this the property that the older gentleman that didn't have a computer and everything was trying to?
No. not
Okay.
this one.
This is a different,
You know what I'm talking about, right?
I know which one you're talking.
The house, I don't know, we've seen this.
I was gonna say, you may have gone before another, but not
But
before
not
this
here.
board.
No, it was with the planning and design board.
No, he's talking about the
Yeah,
planning and design.
April
review.
7th, yeah.
House. Oh,
Go for it.
On case number CEC 24-0114, I'd like to, give the property owner until, to table this until next month. Well, no, I'd like to, give the property owner assess an administrative fee of $250 and give the property owner until, May the 5th to have an issued permit.
Okay, yeah.
I'll
it's-
second that.
What, isn't it before P and Z right now?
It has been approved, so the
Oh, it has.
permit is in review.
Okay.
So he has no,
Building.
yeah, and he has no control over when the permit gets issued. Once it's
says-
in process, he's submitted for the process, it goes from different to different,
So is that enough time for it?
May.
It says that it could be reviewed up to the 25th of April. If I get it approved on the 25th, the 26th, I already have the driveway. I have it done within the day after.
We don't need to have it done. We just need the permit paid for.
Yeah, I mean, if I could pay for right now, I would. But I have to wait for it to be approved.
250 admin, no violation fine.
Okay,
Right.
And-
He's been working with them, given the
Right,
circumstances, I fully
agreed, agreed.
understand.
No, totally agree. and May 5th to have the permit pulled and paid for.
Or
the daily
a
fine.
daily fine of $250.
I'll
If you
sec-
see you haven't gotten it by
Yeah.
then, you may want to talk to the,
Yeah.
Sometime.
thing about,
Yeah.
asking for an extension.
Of course.
Otherwise, you'll start getting a $250 fine on May the 6th, daily fine if the permit has not been pulled and issued,
Okay.
I'll
paid
second.
and issued.
What if it's not approved by the board, by the department that's in right now? Ask for an extension?
For an extension.
Okay.
Ms. Grant, please.
Okay, and then
So
pay
what to do.
pay $250 together with the fee of the permit.
Yes.
All in favor?
Aye.
This motion passes 4-0.
Who seconded it?
Me,
Good to go?
thank you, sir.
You're good. Thank you.
Have a good evening.
Good luck.
Next item, 7.7, for the address 11133 Griffin Boulevard, case number CEC 24-0086, Modesta Molina and Sarah.
What number is this?
Here for a progress report, it's 7.7.
Okay.
Found to be in violation of 5.6.7 off-street parking. Existing parking surface does not have an approach. Oh, we don't have a permit in the system as of today.
No, basically,
We don't have a permit in the system. But I believe he has all the paperwork in his hand.
it's ready to be filed. I was hoping to file it today, but I just got everything on an email today from my contractor, so I can file it today, tomorrow. I can show you. Got all the notarized and all the stuff in there. Just took a while to get the surveys and, to get somebody to do surveys nowadays but I'm ready to file tomorrow. Yeah.
Good.
Okay, so from January the 6th, 7th. And you have everything there, so maybe we can help you. Oh.
I'm sorry. I was gonna say, at the very least, I think we need to set a deadline for a daily fine.
Yes, that's what I was going to, that's keeping with the ones that we did earlier of June the 5th.
I think that's, because again, it allows for that little wiggle room.
Right.
And we know it's gotta happen. You're ready to make a motion?
Yes, I'd like to make a motion in case number, CEC 24-0086. The violation has occurred, property owner until June the 15th to secure an issued permit. If not, a daily fine of $250. In addition to the $250 violation.
I'll second. All in favor?
Aye.
Aye. Any opposed? Motion passes 4-0.
Appreciate it.
Thank you,
Sir.
sir.
Have a good night.
Good luck.
I'll get it done. The
Yeah.
contractor's a good guy. He's a busy guy. He's honest. I worked with him many
You should have
years.
told that person that just walked out, give him the name.
He's a battle guy. He's busy. That's why it took me a little while, he couldn't get the surveyors. to come,
Right, right.
But I got everything.
All right, sir.
Problem.
Good luck.
Good
Yes.
luck. We are moving to section 8 of the agenda, fine reduction. Section 8 item number 8.1, 8.2, 8.3, 8.4, 8.5, and 8.6. These are for the address located at 720 Northeast 117th Street, for case number CEN-24-381, CEN-24-383, case number CEN-24-596, case number CEN-24-652, case number 24-653 and 654. Property owner Jeffrey Icahn is on Zoom with us today. Jeff, can you hear us? Jeffrey? There he is.
Well, he's unmuting.
Hello.
There he is. Okay, so the several cases were issued for several violations. All cases are now in compliance. And we have filed affidavits of compliance for all the cases.
Am I reading this correct, that the offer was for $1?
That's correct.
Have all the, has this, every citation been complied with as today?
Yes, all the citations are now in compliance.
I have several questions. I'm
And the
sorry.
total of all the cases together
Is over 30.
by one?
You can do one by one, or you can do the total. It's up to the board.
I think in this case, we need to do one by one because 4 of them do not incur dailies.
No, I saw that. That's why.
Yes, they're different.
Exactly.
Exactly.
I think in this case, we do have to.
I have no problems with that.
But I've got several questions.
You speak into the microphone so he can.
I'm sorry, if you turn to it's not easy to turn. If you turn to the page that has the breakout of all the violations that resulted in the liens and everything else, there are 5, I'm guessing those are admin citations. 4 of them are 25 and 1 of them is 75.
Well, there are no admin citations. All of them were,
Those stem back
What?
years.
oh, Linda, okay. In the lien search, there are open, admin citations. Yes, you're right.
And we have 2 open permits.
Open permits. That's correct. This house has been vacant, for many years. And when we cited the property, no one was living there.
So 2 open permits and 5 open admin citations. That's concerning. One's an AC and one's paint. Do you have this page, Judy? It should be in the first one.
Yes. I have to submit to the court that, to the board, that the permit that's open was issued in 2017.
Okay,
This is before this property owner even owned his
Gotcha.
property.
okay. All right, so that's neither here nor there. What about the 5 admin citations?
The admin citations. Are they? No, these have been during, his ownership. They have been in the last couple of years, yes. Correct. They were, yes. 2 were issued in 2023 and 3 were issued in 2024.
So that's this current property owner.
Correct. And I would like to read them onto the record. Case number CEN-23-437 for $25. CEN 23-438 for $25. CEN 24-382 for $25. CEN 24-594, $25. CEN 24-655 for $75.
We really should need to deal with those too.
I'm not even, I'm sorry to interrupt over here. I'm not even sure why I received those citations. So I'm assuming if my assistant didn't pay it, it's because we're still not sure why we were given any of these fines. Everything was done in compliance with the proper dates, with proper everything, and we're still here now, sitting for an hour and a half to get on this
Sir, I
call.
need you for the record, state your name and your relationship to the property,
And can
please.
you take yourself can you put yourself on the camera? We
And
can't see
Please
you.
open your camera.
I can now. I'm not in the country, but I can.
There you are. There you are.
And has he been sworn in? Okay,
Okay, good.
Yes.
thanks. Okay. So should we attack 8-1 first?
For the record, this is a non-homesteaded property.
It's non-homesteaded.
Yeah,
It's a non-homesteaded and it's vacant.
Okay, in the first one, agenda item 8.1, there are no daily fines. The only fines that are there are the violation fine and the admin fine, and then the applicable filing fees. I am not comfortable reducing the basic fines. I mean, once we've adjudicated that there's a violation, I don't think it behooves us to go and lessen the basic code violation and admin fine.
I agree.
I'm in total agreement, because, it's been our, stance from prior
Mhm.
cases that do not
We-
waive or reduce the
Right.
administrative costs or the, initial fine.
Right.
Or the filing fees.
It's against the code.
So would you like to make a motion?
Yes.
Well, actually, it's not a motion,
No,
he's
yeah.
offering $1.
There is a motion, right. My motion would be that we do not accept the $1 offer.
I'll second that.
All in favor?
Aye.
Motion passes 4-0. Then my motion would be,
Oh.
I'm sorry, because I would have to make another motion for it to stand, wouldn't we?
No, it's already.
Okay, then already it is what it is.
Already
Thank you.
assessing
Gotcha.
It's already assessing an interest charge of 18%.
Gotcha. Okay, you're right.
So we do nothing. We can explain to the property owner that we're rejecting the offer of $1.
I hear you.
Okay, due to the costs that are outstanding on 8.1 are due to the ruling of finding of a violation occurred and the administrative costs that were assessed to it, as well as the filing fee associated with placing the lien for that violation. You also have, on that case,
So-
a interest charge that's accruing daily.
So on the first violation, sir, and if you've got them in front of you, it's CEN 24-381. That fine amount, we are saying will stand. We are not accepting a reduction on that.
Okay.
Now to, same thing with agenda item 8.2 with, we're on this one.
How much is the fee on that?
On that one,
111,
611, 19.
That's as of today.
Yeah.
I mean, there's an interest, so you'll have interest accruing until this is paid.
At 18%.
at 18%.
So you have to get an up-to-date total when it's paid.
And on violation 24-383, same principle. It's no daily, it's just the code and the admin, and then the interest that's accrued and the filing fees. So
There's nothing to reduce
right.
it by.
my motion is that that stands.
And again, what were these for in violation of?
This one was a fence maintenance issue, sir.
Right, so,
And the
I
first one
mean,
was paint.
do you
Clean.
expect, okay, so again, these are all violations that unless I live in Biscayne Park or I've been in the neighborhood, no one's reading the laws that the paint has to be up to a certain par and the fence has to be up to a certain way as well. So, it's one thing to ask to request me be in compliance, another thing to make me pay for fees, which I don't think are fair or relevant to my situation. You asked for something, I came into compliance. Now you want to tack on the interest and fees, and you think that's fair on my part to have to
Yes.
pay all these?
Sir,
Yeah,
every
that's-
property owner, be they absentee or otherwise, has a responsibility to follow the laws and rules, and it is the same way in every municipality. We are not unique.
You are
Whether
unique. I've
you
never
live
received a
here-
fine for that in any property, and I've had many other properties in Miami.
Okay.
There was a hearing and there was an order of enforcement. The hearing was on September the 18th of 2024, and that's where your violation came into place. You had been provided notice at the time, but the findings of that order of enforcement were that a violation had occurred and you were assessed a fine of.
Right. Never received notice, never received any of that, especially in September. But
And-
either way,
Okay.
His assistant attended the hearing.
Your assistant attended that hearing, I believe?
okay. And okay, so you're basically telling me that we were not in compliance at the time. So, I mean, you're saying the fees were assessed at that time. Is that correct?
Or
I would like to bring
or
it
the
to the
code
attention of the board
violation.
that this is a fine reduction hearing. We are not litigating the case.
That's true.
Okay.
Oh,
We're-
you're
we're
right.
just-
Thank you. You're
I was
right,
just giving
Doreen.
you
Thank
some
you for that
information.
reminder. Yeah, we're here solely to deal with fine reductions. We are not rehearing the original cases. Okay, and the next one is CEN 24-596. And that's also a property maintenance. Again, only the code violation, the admin fee, and the accrued interest and filing fee. So I would move that fine holds,
You're making a motion to deny.
the
the
$1.
request.
Correct.
I'll second the motion.
All in favor?
Aye.
Okay, that's that one.
Not even sure why I'm here exactly, to pay for court fees again when I'm being denied from even negotiating. I appreciate you guys.
Sir, we do not negotiate on the basic fine, the fine for the infraction, the
I mean,
administrative.
isn't that why I'm
fee.
here?
Okay, please, we have two more at the end. We have one more in this situation. Then there are two that incur daily fines. Those are the ones we will negotiate on. We do not negotiate on the code and the admin and the accrued interest. So there's one more having to do with the swimming pool, and that is CEN 24-652. I would move that we do not accept the $1. That fine stays as is.
Second it.
All in favor?
Aye.
Motion passes 4-0. Okay, now,
On item 8.5, we are making a recommendation of $2,000.
I'm sorry. hon.
The fine owed is over 14,000. We are making a recommendation
Again,
of $2,000.
again, miss,
We haven't-
we were in compliance from before the date. There is no reason I would have to pay another $1.
Excuse me,
Go ahead.
let Ms. Grant finish.
We are making a recommendation of $2,000, which we believe will cover cost and the time it took to come into compliance. This is in case number CEN 24-653.
Again, I make a motion that the $1 Mr. Khan offered is not acceptable.
Second it.
All in favor?
Aye.
Okay, now, on the swimming pool issue. $14,476.19 as of the date of this form. It's probably gone up from there. So what is your offer on that?
$1.
I've already rejected that, sir. Did you miss that part?
I
You've
have.
rejected that.
I've been in compliance from before the date of expiration. There is zero reason that I'd have to pay. The fact that your compliance officer cannot get onto my property is not my issue. He was able to
Well,
give me
Actually, it
violations.
is. Actually, sir, it is.
Show me in the statute where it says that he has to have access in order for you to charge me the fines.
Okay.
Please, I'm not an
All right, We're
attorney.
getting
but-
nowhere. Sir, we're getting nowhere. Do you want to make an offer?
No, I'm not making an offer. I will appeal if
Okay.
I have to. Everything was in compliance from before that date. I have emails, I have pictures, I have everything done that was sent in. I refuse
So
to
we're
pay
getting-
another
we're
$1
getting
for
no-
everything that I'm already giving you. I will appeal if I have to. I'm not paying you guys. I'm just letting you know right
Okay.
now. I'll get an attorney. I'll get everything on top of this because this is ridiculous.
Okay, we're getting nowhere.
We have muted him. You can go ahead and rule. We have muted him.
So there's no one to negotiate with. I mean,
So therefore, the fines as they are stand, everything stands. We
I mean,
can't
I-
negotiate
I agree
anything.
with Doreen. I think that's a very fair number,
We can,
but we can't negotiate with ourselves.
Why would I want to negotiate with a number when I was in compliance from before the date that you requested of me? I don't understand. Why would I pay?
Sir, you,
there's a fine that goes along with the violation. There's a fine that goes along with the administrative fee. There's a cost that goes along with the filing fees.
n-
Those
not
need
being
to
in
be,
I just wanted to have a
Right.
question of Doreen and the code. As to date, there's been no, has there been any, has there been any compliance that we know of? Has this been rectified? So
Yes, those violations were rectified and the fine stopped. Yes, yes, in
So,
November.
stopped as of the date that that the village was able to go out there and verify.
Verify. And that was explained to Mr. Khan that we had to get on the property in order for us to get our own pictures of compliance.
Right, so it was from, we're just looking at the period
November 18th,
October the 2nd through November the 18th of.
correct,
So a total of $47 until the village was able to get onto the property,
within
7
1,000.
days.
validate that compliance had been met.
That's correct.
Thank you. So I think
Well,
you made a motion, and Judy?
Judy seconded it.
there's just no
to
point.
deny.
We'll deny the $1 and.
No,
say-
okay, so 1 second. If you're telling me the minimum administrative fees like you guys have with the last cases, which you say you can't obviously reduce, then yes, I'm willing to pay those fees. But above that, any fee that he couldn't get onto the property when I wasn't aware that, like, I need to be in compliance with him being on the property, somehow he's able to give me 3 violations, then didn't come onto my property, but he couldn't get me into compliance without coming onto my property. I thought that was interesting. I'm willing to pay the minimum fees, but $1 above that, I don't think is fair.
Sir, you keep sticking with your dollar. That's really not how negotiations work. There's no
Again,
point in
like I
us going
said, I'm
further.
willing to pay
There-
you administrative fees. I'm willing to pay whatever you said your minimum fees are, but to pay $2,000, I don't even have the money. I'm not like it's like I could even afford it. Like the reason why work wasn't done on the property is because I've had a lot of issues with it. I don't need to go into my personal reasons for why work wasn't done, but hitting me with more violations and more fines is not helping the situation, especially after I came into compliance.
And sir, it's a non-homesteaded property. That makes it a business. So now there are the 2 remaining cases that have the larger daily fines. You've made it apparent you don't want to negotiate on them, so they will stand as is for the moment.
And they will stand accruing 18% interest.
Okay?
As I said, if you're willing to take the minimum fees you guys have, I'm willing to negotiate that. That's what I'm willing to
Oh,
pay.
all right. So you denied, so let's bring it, he said he would be willing to pay the, I believe for this next one, it was,
Well,
500 and a filing fee of 21.19. So if I understand you correctly, you're offering $521.19, which is a $250 violation plus the $250 admin fee and the filing fee of $21.19.
Correct.
That, no, yeah. That's the one we were hearing, 8.5. So that's what, and that's all that you're offering on that. When the total amount comes out to $14,476, because there was a daily fine, a total daily fine for $47, 47 days of $11,750. So I didn't mean to, I just wanted to clarify, was that your offer, $521.19?
Correct.
Okay. Well,
my motion would be to not accept.
I'll second.
All in favor? Aye. Motion passes 4-0.
Sir, had you let us on the proper, let the village validate, we wouldn't be here with this daily fine of this. So,
Yes, and you can be gracious enough to dismiss it as well. And so you're aware that everything was done prior to the compliance date. So
We're not aware of any such thing, sir.
you are,
They're
like
aware
he
of-
just said, he knows that
No,
if we would have let him on the property the right date, this wouldn't be
That-
happening right now. So if you would be gracious enough to
Pat,
give me that
no.
reduction, I'd appreciate it, but you just don't want to.
You're putting words in his mouth. That is not what he said. You
Okay.
did not allow code on property. It took
I
47
didn't allow
days.
code on properly because I felt like the only way he gave me those violations
Okay.
was
All
to
right, sir.
trespass on my property. And if
Sir,
he
you very
trespassed, he
much
can
are in
trespass
control of
again.
your- Okay. You are very much in control of your own fate. You chose to handle it the way
You're
you
right.
did.
I'm gonna
This
take
is
this
how we
higher up
have to
also.
handle it.
I'm also gonna
Okay.
take this. It's not,
Right, not, so, just to restate the motion, there was an offer of $221.19.
$500.
$521.19. It was,
Denied.
Gail made the motion, Janie seconded.
Mhm.
Like to make another offer, sir? Okay. Oh. Like to make another offer, sir? If not, we'll proceed to the next case.
I mean, $1,000 total?
I mean, we have to. be-
What did the village recommend on this one?
$2,000.
$2,000?
I'm going to trust staff. They know the amount of time, effort went into all of this and what, that's a cost to the village. So I'm going to trust staff.
I make a motion on the EN
We'll talk about it.
24-653 that we do not accept the offer.
I'll second. All in favor? Aye. Any opposed? Motion passes 4-0.
Make another offer?
I can't afford any offer. I don't know what you want me to tell you. Anything I'm giving you, I can't even afford. Like, I can't afford to pay you something I don't have.
You heard what one of the members said, that they are putting a lot of weight behind what the village recommendation is. The village recommendation is $2,000. We can't direct you what to make an offer for, but what you have the potential to get this thing resolved for today is a lot less than $14,000. So just keep that in mind. Do you want to make another offer or not?
That's like saying I should accept a 6-year sentence for shooting someone instead of a 25-year sentence when I didn't shoot someone. It's hard for me to accept when I don't have the money. I'm sorry. Like, I understand where you're coming from. I'm trying to be as fair as possible here. I understand you guys have paperwork costs and filing costs and all that, and I'm trying to work with you here, but I don't know what else to say. You want to charge me $6 to $8 grand on all these cases? Yeah, I can't afford that right now. For me to pay
This
$2 grand,
This is
right?
for this case. The second case may be, the last case may be a different story.
Is this?
All right.
But again, this is $2K for one violation. I still have on top of that the violations before as well. Which, okay, again, this it's not something I can afford. I can afford $2 grand for all of them. I can't afford $2 grand on each.
There's always an easy way to avoid fines getting to this level, and that is to work with code to come into compliance. You chose another route, sir. That's why we're sitting here tonight.
Doesn't want any.
I don't,
Yeah,
but
no,
I don't,
this is-
I don't see what time,
right.
or what
All
costly
right,
matter.
sir. You know what,
Other people are here for
Yeah,
fine
it's true.
reductions who
Thank
want
you.
to work with us.
sir, if you're not going to go along with what has been put out here, then we might as well end the conversation. We do have folks that have patiently waited, but because I'm not getting a sense of negotiation with you. You understand where we're coming from. You understand the costs involved and why we're advocating for that price. But you're not willing to go there. So
I'm willing to give you something for it. I'm not willing to give $2,000. I don't see
Okay,
what
all
other
right,
cost
then,
it could have
sir,
been by waiting for
then
me to
on-
come into compliance. Doesn't cost you $1,500.
Okay. Then there's no point in hearing the last two cases.
No, there is a,
Oh.
because we should give him an opportunity. He only
To
has
say
one
no on the other one.
case. He
Okay.
only has one
All right,
case.
so on this one, it stands as is and continues to accrue. Okay, there's one more case, also maintenance and cleanup. The swimming pool was a mosquito breeding ground. Same principle, it's 14,470.19. What is your offer on the last case, sir?
$1,000.
I make a motion to not accept the $1,000 offer.
Second.
All in favor?
Aye.
Aye.
Okay. Sir, anything else?
Nope.
Okay, thank you, sir.
What's the end motion? What's the final motion?
Everything stands. The four that were no daily fines involved, they do stand, and then I have to say the other two do also because he wouldn't negotiate.
Second.
We're not in the business to negotiate.
Right.
It's basically to
To
accept an offer.
facilitate, to facilitate.
They're off the city, it's.
That's a 4-0. Thank you.
And I remember very well, I'm sure we all do,
Yep.
that he would not allow
Right.
So
the code officer back. So that's why we're here where we are tonight.
Next. Yes, the next case is 8.7. This is for case number CEN-24-289, located at 931 Northeast 120th Street. It's owned by 931 Northeast 120 at LLC. Asking for a fine reduction. Fine is $7,500. Our recommendation is $1,000.
And the offer in this case is 150, I believe. Again, we're in the same situation. That would be below our code fine and the admin fine. So I'm going to go right on and say, I would vote to reject the $150 offer.
could you say what the fine was?
I'm sorry.
If there
It
were
was
significant costs,
painting.
yeah.
It was painting. The total fine is $7,500.
It was a 200, it was a daily fine. of
Daily
250.
fine of $250, of course, the admin of $250, the code fine of $250. Because it was exterior painting required.
And Doreen, you said that the recommendation from the village is 1,000 and you took into account the time that y'all had to.
Yeah, it took to compliance, and how many times we brought it to the board, administrative cost, and how many inspections were done.
You think that's a fair and reasonable amount?
$1,000,
That's a fair and reasonable amount for the time that y'all put in there?
I believe so.
All right, I mean, based upon, is a $150 offer? That's what the offer is?
Yeah, I didn't know what was the administrative fee, but if the city recommends 1,000, we'll take it.
You'd like to make the offer.
Oh, I'm sorry. Then we'll like to make the offer for 1,000 as per city recommendations.
All right, well, I'd like to make a motion based upon the Ori Tennis amendment to the fine reduction to $1,000 on CEN 24-289 to accept the $1,000 fine reduction amount for the property at 931 Northeast 120th Street.
I'll second it.
All in favor?
Aye.
Motion passes 4-0. Thank
Thank
you
you so much.
Yes. Do you want to come and sit in the office tomorrow? Are you able to? You can make, absolutely. Okay, thank you so much.
You have a nice evening.
Thank you.
Yes. That case is under item 7.8. This is for the address 11920 Northeast 11th Place, case number CE 25-0178, Alina Perez. They were found to be in violation of section 8.4.3.1 property maintenance. There's a tarp over their roof, and that's against the code. We are asking for an order of enforcement in this case. Into the evidence, we presented a letter that was sent by counsel for Ms. Perez and notes from village attorney.
Doreen, does Ms. Perez have a copy of Brad's?
No, we didn't.
That's critical. I think she would definitely need to, that's only,
We can provide that to her.
please. I'm sorry, could you identify yourself?
Sure, I'm
Really?
Alina Perez. I'm the property owner.
For providing this, because that's a really critical.
I will tell you, during Hurricane Wilma, I lost my roof and I did a battle with the insurance company. What I did was I documented photographic stuff, and that was able to stand. So I was able to move forward based on the photographs we took of the exterior of the roof, the interior of the roof. And therefore,
To have it
right,
legal.
right. So,
take on it. So in other words, if you see what Mr. Weissman has pointed out, you can insist they come, memorialize the way it looks now, and you can go and move forward. You don't have to deal with, because he admits it could take years.
years.
Yeah, I have a trial set for, I have a trial set finally for August and mediation set for June. Citizens has been a nightmare.
Who is your judge?
Oh, I have no idea. I'd have to ask my lawyer.
Is it filed in Miami?
It is in Miami-Dade County. I have the case number, but I think you have
The
my,
case
yeah.
number's in the backup.
Yeah.
As you can see by what the village attorney has said, and obviously you're going to want to reach out to your attorney, you can begin the process of moving forward as long as they come and memorialize it, inspect it, take their pictures. You don't have to wait, and you probably don't want to wait through a hurricane season.
Yeah, I mean, I was trying to wait for the trial because I was told by the attorney if we took the tarp off and I didn't fully repair the roof, that then it could impact my case, meaning
You
I'd have
see what-
further
you see What
damage.
the village's attorney is saying.
Yeah,
Yeah,
But in light of the fact that she has a June trial, can we give her
Yeah, no,
no.
till July?
yeah, I've been
Mediation,
waiting for
August.
mediation in June and trial in August. Yeah,
It's a 24 case, so the chances that you go to trial are probably pretty minimal, unfortunately, because it's a fairly new case. So you probably won't go to trial. I think mediation is probably your best chance. I think what the issue here is, and I deal with these cases, is that what kind of claim is this? Like, is this a roof claim
it's a roof claim.
based on what?
It was a storm in
citizens.
2022.
Just an unnamed storm?
No, it was one of the hurricanes. I can't remember the name of the
So
hurricane.
you're saying you had a wind created opening?
Yeah, it
that
was a wind
caused-
created opening. They did accept my claim, but grossly underpaid. I couldn't do anything with the roof. And so then I don't know, I got a lawyer and they've been dealing
So
with
that-
that since, yeah.
That's actually good for you, the fact that they accepted it as compensable, and it's just a matter of like how much. So you've already
Yeah.
cleared that hurdle, so it's really gonna be a damages trial, which tells me that's probably gonna get resolved.
Mediation.
Probably.
I would hope so. That's my hope. I just want to fix the roof.
So what,
Yeah.
what I'd like to see us do is give even an August date. But, and hear me out on this, the only reason I want to give a deadline with the potential for a daily fine is we're finding too often when we don't incentivize,
Nothing gets done.
we keep doing this forever.
No,
If in August, it still hasn't been heard, it's still, well, it, I shouldn't say that because as you can see by what Mr. Weissman has said, you can go forward. But yes, with the hearing and the mediation coming this close, there's no point in telling you go get a roofer and fix the roof right now. But obviously it can be done. So I would
Okay.
like, again, to set an August deadline, but set the $250 daily fine. If there are more extenuating circumstances, Ms. Perez can come back in front of us for an extension. I like incentivizing.
so what would she have to do? She'd have to come here and seek an extension by the August,
We've dealt with roof cases like this before. It's not unusual, unfortunately.
What do you, like to go ahead and make a motion so we
Yes.
can understand what?
Do you know when your court date is in August?
So they gave the attorney a 3-week trial period of
Right.
starting at the beginning of August.
no, it's a cattle call. So basically, every case that is on that August trial docket, they'll go through the case calendar call and say, you ready? No, Judge, we got a problem. Okay, so we'll continue. Okay, you're number one backup, you're number 2 backup. So that's what I'm saying. They'll rank the cases based upon oldest to newest. So a 24 case is going to be at the bottom of the list. So you can only try one case a week, really. So there might be 50 cases on there and only 3 cases potentially will get tried.
But I would also show the email from Village's attorney to your attorney, because it gives you some wiggle room then to get started. But how about if we make, well, for our August meeting, that we ask for compliance by August 12th? If not, a $250 fine daily, but if there are issues, things are still not where they need to be for you to go forward, come back at the August 13th meeting.
Okay. How do I do that? Should I put myself on the docket, call the village, or
Yes,
if I need to come back?
You would call the village and ask
Right.
it to be heard.
Okay.
Right, it'd be up to you.
Yeah.
Otherwise, a fine will start.
Right.
Yeah.
So
Okay.
just keep in touch with code and just kind of let them know where you are and
Okay.
what's going on, so nothing gets lost in the translation.
Okay. I'm hoping June we can.
Yeah, let's say you don't settle, let's say you don't get reached at trial, then come to the August meeting and say, I need an extension or a continuance because it just got moved till November or whatever. But tell us what the story is then.
Okay. Can I keep this or
Yes.
take a picture
Yes,
of it?
that's
or-
for you.
Yeah. Okay.
I want to get. Actually, doing it hasn't been seconded. I don't believe.
No, it has not. My motion would be that a permit to be obtained and put in place by August 12th. If not, a $250 daily fine, but with the property owner having the knowledge that if things do not work through as they need to for her to go forward, that she comes to the August 13th meeting for a progress report and a request for an extension.
I'll second.
I have a question for a permit or removal of the tarp.
You've got to get that permit for the roof, because just to take the tarp down, you've still got a roof problem.
Yeah, I know, but the violation was for the tarp.
Yeah.
So I'm just.
You need to have,
It's for the tarp.
but you need to have a permit paid for the roof.
For the roof.
Because in
But-
reality, we look at it as if there's a tarp on there, the fair assumption is that there is a leak there.
Right.
A leak, but doesn't mean the roof has. to
That
be-
doesn't mean
Yeah.
exactly.
I mean, It might
Okay.
just be for a little bit of tar, which you don't even have to get a permit if the homeowner does it themselves.
It depends on the size of the
So I'm
damage.
just
But
saying.
I have a feeling if there's been an issue with the insurance.
Cover the
She's already telling us that she needs a whole new roof. And basically, if there's anything, if it's more than 25% of the roof that's to be repaired, you gotta do the whole roof. So that's what she's saying they're going for.
Okay,
An issue permit by 8. Well, you said
8/12,
or $200.
but with the knowledge that things are still inked and not working out, at August 13th meeting with a request for an extension.
Okay.
And couldn't she just go and get a roof permit and she's got 6 months to put it in? So, yeah, so you can go get, you can go get your roof permit and you got 6 months to put it in, so it'll be after your litigation. So you might want to get the permit now.
Oh,
So
okay.
whenever you get the case settled, they can just start doing the work.
Yeah, you don't have to wait for this to be adjudicated.
Right.
You
Okay.
get your roofer in place,
Yeah.
decide what you want.
And then wait for the money to come in after the settlement and then they can just go.
You have 6 months. The only thing we look at for compliance is that you have a permit in your hand and you've paid for it. But we know the roof isn't going to go on there overnight.
Yeah.
You know, it's going to take time depending on what you want, et cetera, et cetera. So, yeah.
Okay.
So you may be fine with August 12th.
I'm hoping.
Again, if not, come back.
Okay.
I'm sorry, did I get a second? Okay. All in favor?
Aye.
Opposed? Motion passes 4-0.
right.
Ms. Perez, thank you.
Thank you. Have a good.
Good luck.
Next item, 7.3. The address is 805 Northeast 115th Street, case number CE 25-0152. For Daniel Lopez, we are asking for an order of enforcement. They were found to be in violation of section 18.4, permitted days and hours of construction. I would like to enter into the record police report number BP 250-302-000-224, in which the police officer states that they were found working on a Sunday, March 2nd, 2025, at approximately 11:35 in the morning. There were 3 gentlemen working, and working on a Sunday is not allowed at all in the village.
Well, if the property owner's not here and nobody has any questions, I'd like to make a motion on case number C-5-2. The violation has occurred. Assess a fine of $250 and administrative costs. I have a second.
I'll second.
Can we get a pay by date?
Oh, to be paid by, April the 30th. No, it's not an or. I mean,
If he doesn't.
We bring it back for intent to lien.
yeah,
Oh.
'cause I was gonna say, it's not a daily fine.
Yeah, there's not an or,
occurrence.
no. That's perfect. Gail and Judy, all in favor?
Aye.
Aye. Any opposed? Motion passes 4-0.
Last case, 7.1. Address is 701 Northeast 119th Street. It's for case number CE 25-0248, Argenta Group Investments LLC, in care of their registered agent, Augustina Fernandez. We're asking for an order of enforcement for double fee permits, section 16.14.1. They installed the driveway without permits.
Yeah.
Yeah, he's got the wood there.
I was gonna say, have they, now obtained a permit?
They applied, but they have not obtained a permit. They applied on April 14th, a couple of days ago.
I see the gravel's been removed.
Right. They removed the gravel. They are trying to reverse it and apply for a permit so they can reinstall the driveway.
There's no questions. Do we have a motion?
Sure, on case number CE-25-0248, the violation has occurred, assessed fine of $250, administrative fee of $250. To have an issued permit by June 15th, if not a daily fine of $250 per day.
I'll second. All in favor?
Aye.
Any opposed? Motion passes 4-0.
And those were all the cases we brought before the board tonight.
Got the, 7-5.
7-5.
Oh, they're for 7.5. You're right. Apologize for that. Item number 7.5 is for the address 10831 Northeast 10th Avenue, case number CEC 24-0120 for Maria Laura Laus. We were going to bring this for a progress report, but we are happy to report that the permit has been issued. Yes. Permit has been issued for her driveway and work is about to start.
Nice.
So we can effectively close the case,
That's
Well,
right?
but I don't see where we've ever ordered any type of
That's true.
administrative
We
fee
didn't.
or anything.
We didn't.
Or that if a violation had occurred. And, I mean, this has been, we've already had two orders. I mean, a notice of violation was in December the 30th of 2024. We had an order of enforcement of February the 12th, 2025, tabling it to March. We had an order of enforcement in March of the 12th, 2025, tabling until April, to find out today that a permit has been issued. And when was it issued?
13th, I believe.
March 15,
March 15th.
2025, yesterday.
Had to bring this back before us with all the paperwork and everything, and the village's code enforcement officer going out and checking on everything. So if nobody, and if I'd like to make a motion. There are no questions.
Sure.
Case number CEC -24-0120, that there was a violation, assess a fine of $250 and administrative costs of $250. To be paid by April the 30th.
Is there a second?
April the 2nd?
No, there is no second. Nobody seconded, so I guess it fails.
And I just wanted a second to explain. I would have agreed with you 100% had we done it the first day.
Yes.
But I feel like now.
We are penalizing her
she's
when she
in
worked with
compliance,
us.
Not her permit. Now to go back and assess it. But that's why I think it's critical that we rethink all these times when we don't and we kind of give a little leeway.
Right.
Maybe not, but.
I've got it. It fails. That's fine.
But I like to explain my logic.
I
So-
don't have a problem.
How about a motion on CEC 24-0120 that the owner is in compliance, she's come along and that we, and got the permit and about to start work, that we dismiss, or close the case?
Second, all in favor?
Aye.
Opposed, motion passes 4-0.
Thank you. And that was everything we brought before the board tonight.
Okay, now we gotta get to the minutes.
Comment, as I am tired of seeing these table holds or.
Yes. Did everybody have time to read the minutes? Any, any corrections?
6.
Bear with me. Yeah, that's one.
Says failed 4-1. I thought it.
It was approved, yeah. Agenda item 6.6 should be approved 4-1, not failed.
Yes. Saw that.
Oh.
And agenda item 7.5. Agenda item 7.5 should be Judy made the second, because I voted against that. So I definitely would not have seconded it.
Judy.
And, okay. Agenda items 8.1 through 8.10, where it talks about when the fine is to be paid, we don't give a specific date, so it should say to be paid by April 15th, not on April 15th.
that item
So
number?
that's 8-1 through 8-10.
Yes, they paid, we received a check for $14,000.
All right. After all that battle on that stuff.
Do we need to vote on Rodolfo tonight?
Yes, he did send a message. He did send us a message for the excused absence.
I make a motion to excuse Rodolfo Berrientos' absence. All in favor?
Aye.
Aye. Any opposed? This for-
Before we close, I want to let you guys know I'll be out of the country in September meeting. And in August, I will be at a conference. I'm going to try and schedule my June vacation around us.
August and September meetings?
13th and September the 17th. Do we want to try to move? You don't miss two.
September, I'm gone the entire month.
Okay.
August, I'll be back the week after.
You want to try, how does staff, Michael and Dale, how do you feel about trying to move August? Because I hate Judy to miss 2 meetings in a row. I mean, though that's the question, staff would have to give us some dates.
13th.
Okay.
I have 2 trials, 2 jury trials out of town in August. One of them is definitely likely to go.
Do you have dates?
It's like mid-August.
Oh, boy.
But it's like that calendar, you're on a 3-week calendar, so you go any week.
I'm available until the 9th. And after the 6th.
Would the first week be okay for you, Michael?
After. For August.
The first week would probably be the
September
best
should not be
week.
available.
Okay. How does
September,
everybody
I'm gone
feel?
the 2nd to the 22nd.
Staff, how do you guys feel about moving it to the first week in August?
See.
You know, I really like us to not have people miss 2 in a row.
But I'd really like not to miss any,
But it happens. It happens to,
I didn't know what the date.
you know, sometimes
We didn't-
there's,
Uh,
and stuff comes up, and if we can work around it, so
I'm
much the better.
Happy to.
What do you guys think of the first week in August?
So the July meeting is July 16th.
And the commission meeting would be on the Tuesday, but Wednesday the 6th?
August 6th works for me. Leave.
Can you guys check and let us know if August 6th would work?
Either that or you might not have a meeting because if
Yeah, 'cause
Michael's
if
gone and
Michael-
I'm gone, we run at risk for not getting.
Right, that's a very good point, Judy.
So 3 weeks is really not that big a deal.
Okay, so August 6th?
August 6th, that would be great.
Check the calendar to make sure there are no other events on August 6th.
Yeah, let's do that. I can do that right now.
'Cause I would rather be here.
Ma'am. Me too, yeah.
I don't see anything on August for the city. I'm sorry, on August 6th. So we should be okay, gentlemen, that's okay? August 6th, bueno.
August 6th?
Yes, sir.
Vanessa, do you send something out so I can send it to my secretary? Or how do you do that? Okay, because if you rely on me, it's never going to happen.
You are your own.
Days, oh yeah.
Okay.
The minutes have not yet been adopted, or are we going to?
I'm sorry, any more discussion? Anything anyone wants to talk about? Okay, I need a motion to adjourn.
Motion to adjourn.
Accept the minutes.
Adopted.
I'll make a motion to accept the minutes with the
Second.
changes and corrections we've put in.
Second.
All in favor?
Aye.
All right.
Motion to adjourn.
Jay, Judy and Dale for the minutes?
Not ahead
The
of
motion?
myself.
It was Michael.
I second. And I made a motion to adjourn, which was seconded by Dale. All in favor? Aye.
We have a question for you. You have to pay your landlord permit.
Oh, that's right. My landlord permit.